Hello, everyone. I'm Jason Montgomery, partner in Husch Blackwell's Higher Education Group. Thank you for joining the program today. Before we begin, I would like to cover a few housekeeping items. At the bottom of your audience console, there are multiple application icons for your use during the program today. If you have any questions during the webcast, please submit via the question box. We will try to answer all the questions during the webcast today, but if a fuller answer is needed or we run out of time, it will be answered later via email. A PDF of the presentation is available in the program materials folder. This program has been approved for legal education hours. To report your hours, click on the CEU icon at the bottom of the screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow, along with a recording of the webcast for watching and sharing. Toward the end of the program, be sure to complete our short survey. We use your feedback to plan future programs that are applicable to your business needs. That is all for the housekeeping items. Let's get started with our program today. Presenting with me today is Taronda Randall and Christina Miner. Taronda is an attorney in our higher education group. Clients count on her broad experience in college athletics and sound legal judgment to address complex and evolving NCAA compliance, legal, and regulatory issues in college athletics. She brings invaluable experience to her private practice, having served in the athletic departments of major public universities and as a postgraduate intern with the National Collegiate Athletic Association National Office. Christina started at the firm this year and is a senior athletic consultant. Before coming to Husch Blackwell, she attended Marquette University Law School's sports law program, interned with the NCAA, and accepted a position after graduation in compliance for the Big Ten Conference. She later joined the compliance offices of Rutgers University Athletics and Northwestern University's Department of Athletics and Recreation. Now she assists clients with athletics compliance reviews, NCAA infractions, student-athlete relations, Title IX questions, and various hot topics in university athletics, including NIL rules. Christina loves supporting compliance offices like the ones where she launched her career, and she finds it immensely rewarding to help those that still are in the daily trenches of university athletics. And it really is trenches in university athletics right now. So appreciate you joining us today. I'm going to go over our agenda, then I'm going to turn it to Taronda to kick off our presentation. But today we're going to be talking about legal challenges to NCAA rules. They are coming fast and furious. We're going to discuss name, image, and likeness, a hot topic of college athletes as employees. We're going to talk about some of these issues through the Title IX lens, and we're also going to discuss ongoing legal matters. But before we get started, I've been using this same slide of the broken road for 3 or 4 years now. I keep waiting for someone to fix this road, and it doesn't appear like there's anyone that is going to patch this broken road of college athletics right now. So we're going to be dealing with these piecemeal issues on a case-by-case basis. So our goal today for you all is to try to set the stage as to where the issues are that you're going to need to spot on your campus and identify areas of potential risk and areas that you can look to in the future as to what may occur. Really, as we're talking about these issues today, from the big picture perspective, what we're really trying to understand is the economic relationship between your athletes and the university or college or institution that you work at, and what that economic relationship should be. So when courts get involved, when attorney general's offices get involved, when plaintiff's attorneys get involved, they are all looking at this economic relationship. And that is ultimately the basis of a lot of the concerns that are being raised here. And of course, driving that discussion is men's basketball and football revenue in Division I. And unfortunately, there has not been a good way yet for the NCAA or its member institutions to articulate the value that is provided to these student athletes beyond the economic component. So with that, I'm going to turn to Taronda to discuss antitrust, which is at the heart of the economic issues.
Thank you, Jason. So I just want to give a little bit of background before I turn over to Christina to talk about some of the current antitrust issues. So we think back to O'Bannon in 2015, with Ed O'Bannon being the named plaintiff in this case. And the men's basketball and football student athletes challenged the NCAA's use of their name, image, and likeness for commercial purposes. Case took a while. So starting in 2009, finally had a decision in 2015. And the result was that the trial court found that limiting student athlete compensation violated antitrust, and athletes were entitled to receive scholarships up to cost of attendance. So amateurism rules, as Jason loves talking about the constant attack on the NCAA, they remained in place. Fast forward 2021 with the Alston case, same trial court as O'Bannon, but this time the challenges related to restrictions for education-related compensation. And the Supreme Court ended up finding that certain NCAA rules violated Section 1 of the Sherman Antitrust Act. And as a result, student athletes are able to receive up to $5,980 in education-related benefits per year in terms of the actual finance part. So when it comes to the implication of the Alston case, the rule of reason analysis was really solidified as the correct way to look at things. And that's a fact-specific assessment of market power as well as market structure to really determine what the restraint's actual effect on competition is. Judge Kavanaugh's opinion, concurring opinion in that case, provides some interesting language, some quotes that I know our jaded Jason will love. So the NCAA's business model would be flatly illegal in almost any other industry in America, and that price fixing labor is ordinarily a textbook antitrust problem because it extinguishes the free market in which individuals can otherwise obtain fair compensation for their work. And with that being said,
just one point on that. So Toronto is discussing this and setting the framework. Really, this is the building block for what Christina's going to talk about, what I'm going to talk about, and really the underlying challenges are all citing back to Alston and really the court's opinion here that there are certain rules, if they're limiting compensation to athletes, violate antitrust law.
Yes. And we received a comment. There appears there are two versions of this meeting running. So I want to make sure that the people behind the scenes take care of that so that everyone can get their CLE or whatever credit that they desire to get. So that being said, I'm going to turn over to Christina to talk a little bit about the transfer rule. And Christina, I know you have an interesting perspective that you can provide, or perhaps you don't want people to know kind of your involvement in this space.
Well, I think my name, along with some others, got leaked several months ago, so it's out. Good to know. So as Toronto mentioned, having served as the vice chair of the NCAA Committee for Legislative Relief, the majority of those appeal cases, unsurprisingly, were related to transfer waivers. So this Ohio case is near and dear to my professional heart and heartburn. It's a demonstration of really an interesting trend that we're seeing over the last year or so, where institutions, particularly for state schools, are enlisting the support of their attorney generals to challenge waiver appeals. And so in this case, this is really just another example of attorney generals' involvement elevating from waiver appeals to public statements and now filing suit. So this case really began in West Virginia. There was a West Virginia men's basketball student athlete, and then in Miami of Ohio student athlete, Cincinnati student athlete, challenging the NCAA's multi-undergrad transfer rule. And now what we're seeing is we have a collection of plaintiffs, Ohio, Colorado, Illinois, New York, North Carolina, Tennessee, and West Virginia, kind of banded together and claiming that the transfer eligibility rule, specifically bylaw 14551, which we'll get to as to why that's so specific, specifically it restrains student athletes and their market labor of Division I talent. We are talking about Division I for right now. And it also restrains student athletes from freely moving to improve their economic opportunity, personal growth, and well-being. I can feel the eye rolls. These are not my words. I copy and pasted it from the case. The second challenge is the rule of restitution, which I have lovingly determined that I'm going to start calling it the mess around and find out rule by the NCAA. Essentially, what that's saying is that a student athlete who is deemed ineligible and then permitted to participate in competition, contrary to NCAA legislation, but in accordance with terms of a restraining order or an injunction, and then that injunction is voluntarily vacated, stayed, or later reversed, the NCAA Board of Directors may take action against such institution in the interest of restitution and fairness of competition. Examples of that: vacating wins, returning participation awards, postseason bans, things like that. We'll see how that plays out. Again, that's why I call it the mess around and find out. If you would like to play in this space and dare the NCAA, we'll see what happens. So where we were at the very beginning, there was a 14-day temporary restraining order that was granted, and then the plaintiffs and the NCAA agreed to convert it into a preliminary injunction, and the NCAA agreed to suspend enforcement of its transfer restrictions through the end of the 23-24 spring sports seasons. Important note, the injunction doesn't apply to all transfer rules. Again, as I mentioned earlier, this is very specific to one bylaw. I'm having to serve a year in residence. It's specific to undergrads, so this does not affect postgraduate transfers. It also doesn't exempt undergraduate transfers who are academically ineligible, for example, and allowing them to compete. Trial is scheduled for next year. So for our purposes, what that means is NCAA and the membership are fairly handcuffed in terms of trying to enforce undergrad transfer rules until we have a resolution.
So before we move forward, I want to take advantage of this time with Christina because she was on the inside of some of this and can provide a little more background on this NCAA rule and the line they drew in the sand at one point and then what resulted in this. But before I do that, I just want to tell everyone that we are converting her from the dark side to the good side. This is actually a reverse Darth Vader that we're doing with Christina slowly but surely. Even though she was at the NCAA, she is now with us and is seeing maybe some of the perspectives from a different angle. So you were on a committee, you were in the membership, Christina. I just, if you could just talk about the discussions regarding that one-time transfer rule and whether or not the NCAA and the committee you were on were going to grant any exceptions in that space.
So contrary to, I think, what a lot of folks might believe, yes, exceptions were granted, waivers were granted, but quite a number of them were denied for a whole host of reasons. The dark side as it was. We're trying to instill some consistency. I know I can feel the eye rolls. Consistency and some reasonableness. And I think what was really frustrating, but also very tricky to find a balance of was the membership said that we wanted X rule. So, okay, we have a rule, we have enforcement, and then, I need an exception. This school needs an exception. This particular student athlete needs an exception for whatever reason. And then it's this constant stream of inconsistency, the lack of clarity. So as we're trying to put one foot in front of the other and, okay, we're going to step a little bit further here, a little bit further there, it really just, it muddied the waters instead of provided clarity. And so what we were seeing was, eventually there were so many waivers and institutions weren't really clear on where the line was and how the guidelines were being applied. And so they started challenging, first the NCAA staff decision and then CLR's decision on appeal. And it got really, really messy. And I'll just say anecdotally for myself, what became very frustrating was the very same member institutions that, were sitting in voting chairs said that, okay, we need this to go away. There's too many waivers, but we're still 1 foot in, 1 foot out, or the very same institutions and individuals claiming that their case was the exception. And so then it was, okay, forget it. I'm just going to grab my attorney general or call the NCAA president. And here we are. And then I left and abandoned my CLR people. Sorry. So now I can help from the other side, potentially. But that's the environment that we're in, or we were in from a transfer rule standpoint. And now we have this case. And I think that's only going to lead to more confusion as to exactly what is being enjoined and what isn't, and how are schools supposed to move forward, and what are student athletes going to do, which I know we'll talk about a little bit later.
And there was a question that came in regarding what happens, after this agreed upon time frame after the spring of 2024? And I think the answer to that is we don't know. And the NCAA hasn't made a determination as to what's going to happen after that time frame. We're going to talk about the next big issue that they're dealing with here in a second. But I think that they are incrementally trying to address a variety of different issues and are struggling to turn what is a pretty big ship in the NCAA in a direction that is reasonable, consistent with antitrust law, and also is in accord with what their members want, which can differ between schools.
And with that, Jason, you want to talk about Tennessee?
Yeah, Tennessee and Virginia. This was the big case that came out last Friday, and really, again, this is an outgrowth of the antitrust decision in Alston, and again, states' attorney generals involving themselves in NCAA matters, primarily because their large state schools have an interest in what's occurring. And in this situation, at least anecdotally, the conversation was that Tennessee was going to receive some sort of penalty or at least an allegation related to a violation of the NCAA interim NIL policy involving what has become known as third-party collectives, NIL collectives, engaging in recruiting efforts with prospective student athletes. And so in an effort to attempt to rein some of these activities in, the NCAA essentially said all NIL collectives or NIL entities that are operating on behalf of a specific institution are boosters of that institution, and therefore you're responsible for their acts. That includes if they engage in recruiting conversations with prospective student athletes. The only problem with that is, how does an athlete know what their value is if they don't engage in conversations? And so there's a real question, or at least a question that is out there, and I think the NCAA attempted to answer it, and this is the result of this, result in this litigation, is what is a recruiting conversation in the context of NIL? Is any communication with the prospect recruiting? My guess, although I don't know this, is that that is the position the NCAA took. But what ended up happening is Tennessee and Virginia attorney generals got together, filed a case that essentially said that this, what they characterized as an NIL recruiting ban, constitutes an illegal agreement to restrain and suppress competition in the market. So a straight antitrust claim. And the ultimate result of this was the preliminary injunction that came out that basically said NCAA member institutions are not allowed to enforce the NCAA interim NIL policy, NCAA bylaws, or any other authority that prohibits student athletes from negotiating NIL compensation with a third-party entity. So essentially, they're enjoined from enforcing this recruiting rule. And as a result, any entity around the country, these NIL collectives, can negotiate or have conversations with prospective student athletes about whether they're going to attend that particular institution and what value they may receive for their NIL if they attend that institution. Just, one other, quick point before we change slides on this. What was probably most interesting about this case is that the state of Tennessee actually has a state law that mirrors the NIL guidelines and policy that prohibits prospective NIL collectives, third parties, from recruiting prospective athletes using NIL. So the court notes that significantly, and also notes that that's not determinative in their analysis. Their analysis really was related to the student athlete's harm, and the way they got around this state law issue was that they said, well, that may be the case, but it's not just the state of Tennessee where there are going to be recruits coming from. So you can recruit in other states that don't have this restriction, and as a result, that's not determinative in our decision. We're going to look at the student athlete's actual interests in this case. So we got a question, and this is a good question. So any other authority, does that include state NIL laws? So my opinion is that any other authority does not include state NIL laws. However, the reason it probably doesn't matter is because neither an institution nor a state agency was assigned to enforce those state laws. So those state laws really were put in as placeholders to be permissive opportunities in the event that the NCAA did not, in fact, deregulate in the way that they did. So effectively, those state laws, most of them, unless something comes out of left field, are rendered moot by this ruling. Now that that goes to the question is like, can you advise one of your student athletes to violate state law? And the answer to that is you're not advising them in the NIL space anyway. As an institution, you're really not involved in those contracts theoretically. And so these NIL collectives are going to operate. And if someone wants to enforce that against the NIL collective, theoretically they could. I don't think there's going to be an entity that does that. But neither the NCAA or member institutions can enforce the NCAA policy or NCAA bylaws. So what ends up happening then is the NIL recruiting ban is lifted. The court says there are less restrictive alternatives than an out-and-out NIL recruiting ban, that this ban can cause irreparable harm to the athletes, and that there's not significant enough public interest in order to justify the restraint of trade. So in citing and discussing all of this, essentially the court says, look, these athletes have some value in the NIL, but we can't determine what that is if there's not an actual free marketplace. And the free marketplace can only be realized if during a recruiting process, this information is provided to athletes. Now, again, this is pretty Pollyannish in some respects to not believe that it is a straight effort of pay for play, essentially, where institutions are authorizing third parties to negotiate on their behalf. But that's the world we're living in. Institutions are divorced from this process still. What I think really is important to understand from an institutional perspective, because you're going to get this from coaches, you're going to maybe get this from administrators, it's a free-for-all now. We can do whatever we want. And that's really not what this case says. This case really only applies to the third party's ability to recruit. It doesn't allow for there to be any involvement by the institution in the recruiting process related to NIL. So an institution's coach still can't go to a men's basketball student athlete and say, if you come here, we're going to get you $300,000. So those rules related to institutional involvement all remain in place. And they remain in place in large part because of the next case I'm going to talk about in a second. But where is this at from an NCAA perspective? So right now, at least I think some of you all received letters from Charlie Baker, the president of the NCAA, that said that they are meeting with the board of directors and the Division I Council, I believe, to discuss next steps in response to this. We have not heard anything since that letter, and I would anticipate some sort of communication. What I can tell you is that there is a pause in some NCAA infractions cases that have some sort of tangential relationship to NIL. And then, we're going to understand maybe in the next week, maybe by the end of this week, the NCAA's position with respect to the application of its rules, given the fact that they can't enforce what would seem to be a pretty key element, of the underlying regulatory process here.
So, Jason, I know you mentioned it in terms of the NCAA infractions work related to NIL, tangentially related to NIL. Can you give the people an idea, just from your practice, some of the recent issues that have come across your desk or our desk?
Yeah, most of them involve, I guess, a couple different things. And Christina will talk about this a little later when we discuss more broadly NIL rules. But basically, it is how much involvement is too much involvement from an institution as it relates to NIL collectives? And in addition to that, how much involvement can NIL collectives have in advance of a student athlete actually enrolling at the institution, if any? And those, I guess, in addition to that, one other component is if someone's in the transfer portal, how much communication can an institution or a prospective institution have about their NIL opportunities, and how much can that third party have? All of those are unanswered still, and at least were in some respects being explored by the infractions, the enforcement staff in the infractions process. So the reason that the rule still exists, probably in any format, is because of House versus the NCAA. So this is the third part in a trilogy of cases that Toronto talked about. O'Bannon was really about institutional ability to pay athletes, in large part for their NIL, but it was about institutions' ability to pay athletes. Alston was about a subset of rules related to education-related benefits. And House is about, what I would say is like the whole enchilada. Like, it's everything. It is third-party NIL. It is television revenue. And the two big components of this are that athletes should have been able to profit off of their likeness sooner than the deregulation. And as a result, they lost not only their own individual opportunity for revenue, but collective revenue. In addition, they should also be able to profit off of the agreements with multimedia companies to broadcast their games. And really, in those respects, we're talking about Division I men's basketball, Division I women's basketball, and football. With NIL, we're talking about all sports. So all sports are part of the class. And the last really, major issue that occurred in this is that the classes were certified in September and the damages classes were certified in October. So this case is proceeding. And what are the implications here? I guess, it's, I don't know if you've heard the analogy of a play. So if there's a gun in one scene, then it's going to be used in another. And I guess you could say that Alston was the gun and it's getting used in House. And ultimately, this could be the death of the NCAA legitimately, because this is a $3 billion claim of treble damages potentially. Again, the NCAA's lost before this court on the last two cases, and there's no reason to believe that this court is not inclined to look skeptically at any rules that limited compensation for athletes. Happy Thursday, happy leap year day. Sorry to ruin some people's days, but the reality, I do think it is that without a settlement or some other intervention, that this outcome in the House case is going to shape college athletics moving forward.
Good times. All right. Moving right along to NIL, this is another topic. As a recovering campus compliance officer, it gives me heartburn. Anecdotally, I'll say I don't believe that NIL is inherently a bad thing. I think we as a collective industry have made a mess of it, particularly in enforcing and playing nicely in the sandbox, but it's not going anywhere. So I'd like to kind of start this segment off with the best thing we can do is figure out how to make it work. It's going to be here. It's going to be here probably longer than most of our careers. So we have to figure out how to make it work for the best of us. You can go ahead and on the next slide, please. All right, not picking on Florida State. They just happen to be one of the most recent NIL infractions cases. So just quickly kind of going through what happened in this one. It's published, it's public, it's hanging out on LSDBI. Assistant football coach violated NCAA rules when he facilitated an impermissible recruiting contact between a transfer prospect and a booster during an official visit. During that contact, booster encouraged the prospect to enroll at Florida State and offered $15,000 per month NIL deal as a recruiting inducement. Just an important side note, there was no allegation of tampering here. I think sometimes you see a lot of those kind of parallel allegations. That was not the case here. There was an unethical conduct charge for the assistant coach for the institution, and level 2 aggravated for this particular assistant coach. Negotiated resolution penalties, public reprimand, 2 years probation, $5,000 fine plus 1% of the football budget, scholarship reduction, handful of recruiting restrictions, 2-year show cause order, disassociation of the booster. What I find here is interesting is disassociation for the collective for a year, then reporting obligations and certification of compliance. So just one more example of kind of where institutions are, from an NIL standpoint. You can go to the next slide, please.
Just real briefly, we're talking with our folks to address any technical difficulties if some of you folks are not seeing particular slides. So hopefully they're addressing that as we speak. We're advancing the slides that we can on our end.
Oh, sorry. No one else can see this. I've been talking to myself. So the Florida State case kind of brings us to, which I think is just interesting when you take into account some of the cases that we've talked about already, and then also the NCAA's new NIL rules, which again, just don't completely go away because of the Tennessee and Virginia case. So the NIL rules that were adopted in January and will become effective August 1, essentially all they did was codify the interim policy that I'm sure you all have read at least once. And most of those rules already were mirroring what institutional policies were saying, what some of the state laws said, with the exception of the disclosure requirement specifically being tied to eligibility. Again, I think this is more of a mess around and find out situation. As to, is this really going to be enforced and how strictly? But for what it's worth, this set of changes were proposed as a way to provide helpful information for student athletes, so they can make informed decisions about their fair market value and what they wanted to do in the NIL space as a part of a larger student athlete protection package. I'm not sure I personally buy that the result of all this is going to serve the purpose, nor do I think the NCAA is going to be able to enforce, particularly this eligibility piece. But, here we are. Regardless, I think from a campus compliance standpoint, it's going to require additional resources and effort from compliance staffs, again, unless you want to mess around and find out and kind of roll those dice. But I do think it's interesting, and I know Jason's got some thoughts here, that all of these disclosures, while they're also tied to eligibility, also make, all of the agreements subject to NCAA review. So we'll see how that goes.
Yeah, I think so number one, who knows if all of this goes away after the behind the doors meeting with President Baker and some of the NCAA leadership. I don't know. Maybe it changes overnight. So all of what we're talking about is subject to, change here in a short time period, and we'll do our best to update when those happen. But as it stands now, this August 1st, 2024 rule does allow for the institution or the NCAA enforcement staff to come in and review individual contracts. Now, before this time, some institutions would take the position that these third-party contracts, while they may have been maintained by the institution, there are confidentiality clauses there between the athlete and the third party, and the NCAA is not a party to that, nor should they receive those particular contracts, so long as the institution can assert that they are being done consistent with state law and NIL policy. That will go out the window with the application of this rule, because the rule very specifically allows for, and it doesn't say the enforcement staff, it just says, a representative of the NCAA, because if they said enforcement staff, it probably wouldn't have been passed, but such is life. It is, so it will allow them to review those contracts and theoretically make determinations as to whether there are quid pro quo arrangements and so forth. Again, this was all pre-Tennessee, Virginia, and so we'll see what happens post and whether the NCAA makes adjustments on the fly.
And on top of all of that, so you've got the Tennessee, Virginia case. Then you've got this upcoming closed door meeting. I don't know what's going to happen with that. But what we do kind of have that is just out there for public consumption are additional proposed changes to be voted on. I don't actually know if that's going to happen, discussed in April, including a mandate for collectives to follow institutional standards, which I think is just a nice formal way of saying that institutions can't get out of violations that are committed by their collectives. Fine. Also, a prohibition on NIL agreements until student athletes trigger student athlete status. And for our D1 friends, I know we're all aware that that status is now triggered much earlier than it used to be. That may work out well, may not work out so well. Time will tell. And then, of course, permitting institutional involvement, but of course not compensation. You could go over to the next slide, please. All right, which brings us to institutional involvement and exactly what that means and what that doesn't mean. So essentially so this particular blurb was a directive that came out earlier this month, prohibiting institutions and staff members specifically from scheduling or leading meetings with student athletes to discuss terms of a proposed NIL agreement and providing proposed agreements to student athletes or returning signed agreements to an NIL entity. Essentially anybody on an institution kind of acting as that middle person. This was published and then immediately removed. So those that read the ticker that day, you saw it. After that, it disappeared, but here it is. So in light of the Tennessee, Virginia injunction and everything else that we've talked about to this point, I think this really just results in a really fuzzy, thick line between what is permissible and what is a violation. And as we've seen prior and currently week by week here, lack of clarity tends to result in pushback. And so we want to talk about institutional involvement. If not, speaking of pushback, I know Jason's going to talk about some current challenges to NCAA rules.
Yeah, the only other thing I'd say is this particular item, is somewhat disappointing because, it's like you take 2 steps forward and 1 step back in the NCAA processes. So, and on one hand, you have Charlie Baker talking about compensating athletes directly, direct institutional involvement in April, as soon as April. On the other hand, you have a publication from another committee that suggests you can't even have a meeting or discuss NIL, which on its face, I think is most people, reasonable folks would say is ridiculous. And again, the only reason I can talk about this is because all 3 of us worked at the NCAA. So I have carte blanche. As I left there, they gave me carte blanche to talk about them however I wanted to for the rest of the time that I'm involved in this process. No, I empathize sometimes with our former colleagues at the NCAA because, as Christina pointed out, there is not clear guidance. There doesn't seem to be clear direction, and again, really until that NIL House case is resolved, it's difficult for them to to really regulate this in any meaningful way because in some cases they're going to have to talk out of both sides of their mouths, and that creates a really difficult regulatory environment.
I'm glad that you mentioned the fact that you were at the NCAA because at the beginning of our presentation, you talked about Christina and I both being there, and I felt like the people need to know your villain origin story.
So this is me, willingness to challenge NCAA rules. So this is all an outgrowth of what we've been talking about, but so we talked about antitrust and we talked about maybe proxies for challenging in NCAA rules. So that being states attorneys general, which may give an issue more credibility versus individual student athletes. And, significant precedent in multiple jurisdictions that the NCAA has discretion to make rules related to eligibility and to enforce those rules. Going back to the Jeremy Bloom case about amateurism, Jeremy Bloom, for those of you who don't remember, was a Colorado football player that was also a skier, and he was trying to get endorsements for his skiing career, couldn't do it, took the NCAA to court, lost. But that was all pre-Alston, and now we're in this post-Alston era, and so there are with the as cases stack up, more individual student athletes are willing to step in and address what they believe are grievances that affect them directly. So talking about two of them, the first one, and the reason the Statue of Liberty is on here is because it's about a liberty interest. I thought that was really good. Credit to Christina on that. But the first one involved an institution trying to impose a competition suspension on an athlete based upon him being charged in another jurisdiction with a crime. And the court in that case, basically said that an individual student athlete can have a 14th Amendment property and liberty interest in participation based upon that individual's ability to earn compensation and his professional prospects. That's the general gist of what happened there. There are some other nuances related to the process that was involved. But really the important takeaway for me is that if you're a talented athlete and something happens, you do have some individual interest that you did not previously have, at least this court believed you did, a property interest in your own name, image, and likeness and how that's being portrayed and whether being outside of competition is going to damage that. And also a liberty interest as it pertains to the ability to potentially, participate and become a professional athlete. So a very interesting case. The first time that I'm aware those types of discussions around the 14th Amendment were had as it pertains to student athletes. The second case that is on here, Jeremiah Williams, Rutgers student athlete. This is really kind of an interesting play off of the West Virginia case. And so what you see here is that, these are individuals challenging a suspension either by an institution or by the NCAA. This one related to an athlete who transferred multiple times. So he was at Temple first, then he was at Iowa State, got in trouble at Iowa State related to gambling, and then he transferred to Rutgers. And the issue for him became once the West Virginia case happened, that essentially did away with the one-time transfer rule. So he would be immediately eligible as a multi-year transfer. He was still serving or required to serve a penalty related to his involvement in gambling. And the NCAA took a stand that during that time period where you were going to have to sit anyway under our rules as a third-time transfer, you don't get to also serve a penalty. And this court just rejected that argument. And again, utilizing antitrust as the underlying rationale here. So that's a really interesting outgrowth of what happened in West Virginia. And I do think that these are going to potentially become more common depending upon what issue is at stake. One other item that we became aware of just recently, and I'll let maybe Christina can opine on this a little bit, is another case involving a Manhattan student athlete who was, I think, going for his 8th year.
8 years. I don't know if my knees would have held up that long.
Christina, could you tell the folks a little bit about this Manhattan case?
Oh yeah. So I think this fits perfectly into the trend of, if you don't like an answer, appeal. If you don't like the answer of the appeal, go to court and see what happens. I think what we're seeing from particularly the Manhattan case, it's not, it's TRO or like a preliminary injunction and it ends at some point. This particular case is, I'm 100% overgeneralizing, but we don't like the answer. Student athlete wants to continue competing, does not meet the criteria for a medical hardship or any hardship for that matter. Again, I haven't seen the details of the case, so please don't come at me for that. But so exhausted all options and says, nope, unfair, I'm going to court, and then wins. So at this point, for this particular case, there is no, okay, well, we're going to continue digging through this. Once the season's over, the student athlete's done anyway, which I think is really interesting, particularly for those student athletes that still have additional COVID years or anything like that left on their clock, is take your chances, if you win, you can finish out your season, and then whatever happens after that, student's done. They've graduated, they've exhausted their eligibility, they've moved on, and then it becomes, left to any particular institution to figure out what that means moving forward. And one particular thing I think is important for campus folks is this shift in perspective. I think, and I'll use the term we, I haven't been gone that long, have been relying on this, you don't have a right to compete, you have a right to whatever you signed for. That is no longer the case, as we're seeing it in various jurisdictions, in various states are just like, no, we're uninterested in that. And now certain student athletes do have a property interest, a liberty interest, a constitutional right to compete, which I think is really interesting and also potentially dangerous. So, moving forward, whether we love it or hate it, I think we're all going to have to shift the mindset and figure out how we're going to operate moving forward. That's my soapbox.
So with that, I know that people are here, one, because they love the content, it is useful, but some people like the free CLE credit. So if we could get people to complete the poll, it'd be greatly appreciated. Let us know whether you believe student athletes should be employees.
Or whether they already are. You maybe none of the above, they already are.
Said that, I'm not sure. So I'll give everyone a few more seconds to let us know, and then we'll launch the results.
And Taronda, leading into this, is going to talk about student athletes and employees. But to set the stage for this, if you're at the highest level of college athletics, Division I, FBS school participating in high-level football, you're going to receive a scholarship. You're also going to receive up to cost of attendance, so probably an additional $5,000. And now you're also going to receive Alston money, so another $5,980. And then the collective down the road, who may or may not be affiliated with the school, is going to give you a separate contract. So if you add all of these things up, you get why college sports is in the position they are.
So we're going to show the results, and you say that, and I think to myself, the real world, or the afterlife, as I like to call it, may be a disappointment for someone receiving all of those benefits without any real expenses. So in the sense of the crowd, should student athletes be employees, we have 17.5% saying yes. The overwhelming majority says no, and about 19% says, I'm not sure.
And just for the record, for those that said no, if you guys could send me your arguments, because I'm supposed to take the no employee position in a forum at the end of March, and I could use any thoughts you guys have. It'd be really helpful for me.
So student athletes as employees, and in the interest of time, I'm going to kind of provide kind of a high level overview of where they are. And Jason and Christina, please feel free to pipe up if you have any thoughts regarding the impact. So we have the Johnson versus NCAA case. And in this case, we have Ralph Trey Johnson, a former Villanova football student athlete, and later there were some other plaintiffs that joined, that sued the NCAA and nearly 24 institutions. And the argument was student athletes should be considered employees under the Fair Labor Standards Act. And the NCAA is a joint employer alongside the school. The student athletes argue they should be paid for the time that they spend in practice and competition. If they are covered by FLSA, they should receive minimum wage and overtime pay. I'll note that there's a circuit split. The 7th and 9th circuits previously ruled that college athletes are not employees protected by the FLSA. And this is sitting in the 3rd Circuit. We're still awaiting the appellate court decision. So it is possible that the Supreme Court may have to weigh in regarding whether student athletes should be considered employees.
Now, the thing I would note, the really interesting thing here is the court split. I think the way the 3rd Circuit distinguished that is that it occurred prior to Alston. So again, everything building off of this Alston case. And then also, the analysis here isn't dependent on the economic value of the athlete. So that is different in some respects than the antitrust litigation, and in fact how some of these other cases are playing out. So it's, again, this could have effects, at all levels. I can tell you most certainly, I did not consider myself an employee of good old Baker University NAIA program, but I do think that this has bigger ramifications for institutions than some of these other things for more than just the elite level institutions.
So we have the current NLRB cases, and I don't think this is a surprise considering the September 2021 memo that came from the GC saying that athletes will be considered employees on the NLRA. So with the Dartmouth matter, and that is fairly recent, we've had some recent action in that. The regional director found that men's basketball student athletes are employees because they perform work which benefits Dartmouth in the form of generating alumni engagement, financial donations, and publicity, which leads to student interest and applications, kind of that drive for enrollment. And Dartmouth has the right to control the work performed by student athletes. So in the sense of, there's a student athlete handbook, they control the travel schedules, there are care rules regarding practice activities. And the players that perform that work, they do it in exchange for compensation. And so the compensation takes form in apparel, equipment, tickets, early reads for admissions, some of those fringe benefits, if you will, such as academic support, the mental health services that are provided to student athletes and nutrition. And one thing, Jason, you kind of mentioned this, contrary to the ruling in Northwestern stating that walk-ons are not employees, the employee status will be fine where there is a rudimentary economic relationship, and the payments need not be significant in amount. So it really doesn't matter that dollar value, if you will. We have about 9 minutes to go through some other slides. So I'll briefly mention the USC matter, and that the GC alleges that USC football, men's and women's basketball student athletes are joint employees of USC, the conference, and NCAA. And that focuses on the student athlete handbook, if you will.
We're having so much fun, and these issues are so deep that we need to speed up, is what you're saying.
I was trying to do my job of keeping us on task, and I felt like I was doing good, but somewhere the train went off the rails. Well, that being said, we'll turn over to Christina to talk about Title IX, gender equity in athletics, and I think Jason has some thoughts to say as well.
Yeah, why don't I jump in, and we can go through these really quick, because what is clear to me is that Title IX is not going away. So we're talking about all these different issues affecting economic viability of student athletes and the relationship between the institution and the athlete. But in all of that conversation, I do believe it's been discussed, but not in the context of the actual litigation, is what about Title IX, and your Title IX obligations are not going to go away. So as an institution, you need to provide, essentially equitable opportunities for both men and women on your campus, whether or not without regard to revenue generation. Okay, so just revenue generation has never been a justification for not providing equitable treatment under Title IX. And just a reminder of how this is analyzed is, the 3-part test related to equitable participation. You can meet it in one of 3 different ways. Financial support, and what I want to say about this financial support piece is it's traditionally scholarship dollars, and this I don't believe would impact NIL. We don't know what it would mean if you were actually compensating athletes, but I don't think equitable financial support was meant to include direct compensation to athletes if that happens. What it does include, and what we believe it would include, is Alston benefits for sure. Although that has not been taken up or analyzed by the department or OCR in any way. There hasn't been any dear colleague letters related to this. And then equitable treatment, which I think really gets into the heart of where you can see issues arising related to NIL in particular.
And just to go through kind of some of the trends and topics we're currently seeing in the space right now. Again, I'll go through this as briefly and succinctly as I can. Sports sponsorship right? The conversation and the decisions on campuses, eliminating teams, roster management, those kinds of things. So just a kind of a quick note, there's no Title IX requirement that says, immediately cut or reduce teams, and that gets you into compliance. Eliminating teams in generally is disfavored. That's from a really old colleague letter, 2003 colleague letter that is saying that, okay, cutting sports, while that seems like a quote unquote an easy decision, it's not, and that does not automatically result in you being in compliance with all of Title IX. As Jason mentioned, 3-part test. First part has 3 prongs. The other piece is, and I'll get to the Quinnipiac case in a minute, but from a financial aid, fundraising, and budget dollars perspective, just a couple of interesting notes. Total amount of assistance awarded to men and women must be substantially proportionate, and dollars spent on male and female athletes must be within 1% of participation percentage. So this isn't okay, look at your scholarship dollars only. Okay, we're good. That's not necessarily going to be the case. If you look individually at budget or fundraising or scholarships independently as opposed to collectively, you're going to miss the mark there a little bit. If you want to go on to the next slide. And again, not trying to pick on anybody, just examples. Loyola Marymount, so after the 23-24 this current season, quote, due to new NIL rules and pending rules on student athletes as employees, the institution will cut 3 men's teams and 3 women's teams: men's rowing, men's cross country, men's track and field, women's rowing, women's swimming, and women's track and field. So going back briefly to the 3-part test and 3-prong test, the second you cut an underrepresented gender sport, you no longer can meet prong 2, which is history of program expansion, or prong 3, full and effective accommodation of interest, which means if you cut a women's sport, a female sport, you have to meet the equitable participation piece, and you have to meet proportionality. And then there's just a note on the side there. Women's swimmer has started a petition to reinstate those sports. The institution said that they're not going back on the decision, but here we are. And I think just a couple of takeaways to learn from what Loyola Marymount is going through and has already decided. You need to figure out where you on your institution or your campus, where you are in terms of equity. If not, it becomes very difficult to make some of those hard decisions. And just from my own perspective, I think a common theme that, at least I'll speak for myself, I've heard over the years is there's this hesitation or potentially unwillingness to ask some of those hard questions and do the internal assessment, because once you do it, now you're stuck with the answer. But thank you, Jason, for that note. Title IX is not NCAA infractions, right? So we don't have this, okay, thou shalt report all instances of maybe having a violation. That doesn't necessarily exist in this space. So to that, I think it's much better to do the assessment, do the deep dive on your own terms, come up with a plan, be able to show that you're making reasonable progress if you're not already in compliance. Granted, that is very hard to do. And go that route rather than being called to the carpet by OCR or being forced to make some massive budget decision on a dime, as we've seen from some of these other cases. There could be a massive budget issue immediately. And I don't think the courts are going to care necessarily about, we need more time to figure out what we're doing. I think what we've seen is courts are over it. It's, here's the decision, you need to figure it on your campus and you need to do it immediately. So while we have the time, I think it's prudent to do the assessment and be as proactive as you can. And then very quickly, okay, some additional current issues. I think what we're seeing on campuses are being questioned with regard to equity in marketing and promotion between their female and male teams. From an NIL standpoint, athlete facilitated agreements don't necessarily trigger Title IX concerns. However, institution facilitated agreements, or those that are directly facilitated by the institution, will likely warrant additional analysis. So what that practically means is the closer we are getting to permissible institutional involvement on one side for purposes of NCAA rules, the closer you are also getting to Title IX liability on the other side. So again, really important to do the analysis while we can and figure out what we need to be doing moving forward. And we've already seen one class action Title IX suit brought against a Division I school alleging inequities in NIL opportunities, NIL education, and income, specifically through a collective. I know we're over time, so I'm gonna stop talking.
No worries. So some other key issues in the athletic space, and I'll keep these brief because I know Jason has a brief outro to give. With conference realignment, we have some legal challenges coming up in that space. So ACC versus FSU. One quote I guess I'll use in the sense of sometimes happy marriages end in messy divorces. So this is about the grant of rights with agreement with the league that runs to 2036. Just recently, ESPN actually joined that suit. Right now, we're looking at jurisdictional issues and the fact that ACC filed in North Carolina, Florida State filed in Florida. And we have a hearing scheduled for that March 22nd of this year. We have the NCAA Project Division D1. That's President Charlie Baker's project. I think everyone's kind of recognizing the not so secret that the gap between the haves and the have-nots is continuing to widen, so you may as well address it. So it's reimagining a subdivision within Division I that allows a little bit of flexibility for some of those schools with more resources, and they can work with their peer schools to kind of adjust rules in the sense of scholarships, roster limits, recruiting, transfer, NIL. They can touch some of those issues. They also want to empower Division I schools to provide enhanced educational benefits to student athletes, kind of really taking care of your student athletes, if you will.
So just to wrap this up, we could go into maybe each of these slides in so much more detail. We only had a short amount of time. We appreciate you joining us today. We'll do our best to try to push out educational material through our platform and try to get on another webinar soon to provide the update, which, you know, it could be this afternoon, something else happens that changes everything we just talked about. So evolving field, it will continue to evolve, and we appreciate you guys joining us today. The last little note is that, you know, again, we hope the information was helpful. As a reminder, this program has been approved for legal education hours. To report your hours, click on the CEU icon at the bottom. A certificate of attendance, including course numbers, will be emailed to you tomorrow, along with a recording of the webcast for watching and sharing. And be sure to complete our short survey. Again, we appreciate your feedback and anything we can do to enhance or dive deeper in one of these particular issues. So with that, this concludes the webinar, the first time that we've all done a webinar together. So successful, I think, Christina. Thanks for joining us, and we appreciate everyone's time this afternoon.
Thanks, everyone.